Okay, I'm in order to make sure that we are able to have enough time for Q&A at the back end of our presentation, I'm going to go ahead and get started. Thank you everyone for being here virtually today for this webinar. My name is Emmeline Harrigan. I'm the president of the Connecticut chapter of the American Planning Association. There's a lot of thanks to give to Evan Seaman, who is our program chair for CCAPA. He unfortunately couldn't be here today, but he helped pull this panel together and coordinate everything through his firm, Robinson and Cole. Thank you as well to Joel Easley, who's providing technical support from Robinson and Cole. And it's my pleasure to introduce our panelists for affordable housing, what's next? We have 3 speakers and panelists for today. The first is Tim Hollister, who's a partner at Hinckley Allen. He's a well-known land use attorney here in the state of Connecticut and has been an 830G expert, as well as has really served on the affordable housing plan panel to review housing plans and also to help understand like how people are how municipalities are responding to the state statute in terms of the plans that they're creating. We're also joined by Andrea Gomes, who is an associate in Hinckley Allen's real estate group and practices land use law, environmental and municipal law. And we're also joined by Chuck Andre, who is an attorney at Barclay Damon in New Haven. Chuck and Andrea both served as planning commissioners in their prospective municipalities, which I think brings an additional layer of knowledge and personal interest in terms of their, how they have responded, I think, to some of the affordable housing issues that have come up in their own municipalities. And I hope the rest of you look forward to this panel as much as I am. So we will have Q&A at the back end of this, as mentioned. And so please keep putting your comments and questions in the chat in the end. This webinar is going to be recorded. So if you want to share it with other commissioners who weren't able to attend today, it'll be on the CCAPA website. And this is eligible for CM credits as well through CCAPA. So with that, I'm going to turn it over to Tim. Thank you so much.
Well, thank you, Emmeline. Good afternoon, everybody. Thank you for joining us. I'm going to start with a public service announcement. Today is Administrative Professionals Day. So if you have one, or you know one, or you are one, or you used to be one, roll out that attitude of gratitude, because I speak as one who forgot a couple of years ago and was appropriately pilloried by all of my coworkers. So don't let that happen to you. Thank you to CCAPA and Emmeline and Evan Seaman and Joel Easley. And I'm delighted to be here with Chuck Andres and Andrea Gomes. I suspect that most of you feel as though you've been inundated during the past year or so with information and exhortation about affordable housing. And it is true, of course, that in the past 3 years, there has been a reignited interest and national movement aimed at equity, racial and economic equity in housing, understood as including lower cost housing and better, safe, and more accessible housing. And as part of that wave, here in Connecticut in 2021, our legislature, among other things, established the Commission on Connecticut's Future and Development, and tasked all of you planners and land use commissioners, every town, with filing by June of 2022 an affordable housing plan. So the result of those 2 actions led to me being appointed in December of 2021 as co-chair, along with State Representative Roland Lamar, of the Affordable Housing Plans Working Group, a subcommittee of the Futures Commission. And the working group's task, as outlined in the statute, was to make recommendations about, number one, affordable housing plans that were then starting to be written. Number two, how to develop housing opportunities, including multifamily, for all residents of the municipality and its planning region. Coordinating affordable housing with what is called the CON plan, or consolidated plan, which is the state's document that allocates federal housing dollars, such as low-income housing tax credits, and how that compliance should be demonstrated. So it's important to understand right from the beginning that the working group's task was not to deal with 830G, but to deal with general statute section 8-2, the Zoning Enabling Act, which of course governs zoning authority obligations and limitations in all 169 municipalities, not just the ones that are subject to 830G. If you've had a look at our report, I hope you got a look at the working group roster. We were very blessed to have a wide range of perspectives and expertise. We had the Connecticut Conference of Municipalities, the Council of Small Towns, several city and town representatives, several planners, OPM, real estate finance experts, housing administrators, and demographic experts. And I also want to note that we had excellent help and presentations from Glenn Chalder, Jocelyn Eyre, John Guskowski, and Jeremy Ginsburg, and Don Poland was a member of our working group. So we met throughout 2022 and produced a report that was distributed with the agenda for this meeting. And it was the report was adopted by the working group on February 16th, and then presented to the full Futures Commission on March 6th. So today, when we ask what's next in Connecticut in affordable housing, I think the answer, other than whatever the legislature may churn out in the next couple of weeks, and we'll come back to that, is to respectfully suggest that what's next is the report, dealing with the report of our working group. And so what I want to do today is I want to summarize that report to you. And as I do, it's important for you to please keep in mind that I am continuing to wear my co-chair hat. So I'm speaking for the group and delivering a summary of the report, not my own personal views. Now, the working group started with the all-important fundamental understanding of the structure of land use in Connecticut, which is an important backdrop to the report. If you think about it, most of the major governmental functions in our relatively speaking, very small state of Connecticut are administered at the state level by a single state agency with a single set of rules and regulations. Transportation, environmental protection, public health, public utilities, telecommunications, energy, corrections, and so on, but not land use. Where in land use, the state, even though we are not a so-called home rule state, has delegated broad powers in the form of the Zoning Enabling Act 8-2 to each of our 169 municipalities. And of course, it is well documented that that initial delegation, which occurred in the 1920s, was intended to systematically maintain racial and economic segregation. And since then, in the 100 years, the only sort of retreats from that or limits on that have been the anti-discrimination laws, such as the state and federal Fair Housing Acts. So judges from the beginning and still now are mostly directed to defer to local discretion with regard to land use. And the one exception being 830G, but that's not that judges reinforce segregation, but they certainly continue to send the message to municipalities that your powers under 8-2 will not be disturbed by the courts unless there's some egregious error. So as a result, the central issue in land use law and policy in Connecticut for planning and zoning in general, but for affordable housing in particular, has been, should the state take back some of its delegated authority and discretion under 8-2 based on the view that municipalities, for whatever reason, are perceived at least as not responding adequately to local regional, and statewide housing needs. As a side note, I would point out that there are several states around the country, California, New Jersey, Colorado, Illinois, among others, that are having this very same discussion at the moment. So in the past 35 years or so, the principal efforts to rebalance this statewide delegation are 830G, which was adopted in 1989, the 1991 amendments to the Zoning Enabling Act, which introduced the idea of zoning regulations having to promote economic and racial diversity and economic choice in housing and multifamily housing. Then in the year 2000, you had the very substantial amendments to 830G, which a lot of people forget about, but that was a bipartisan and broadly representative commission that it was intended to, and I think did, make a lot of changes in 830G to make it more responsive to municipal and local concerns. So that was a rebalancing effort. Then you had in 2007 the incentive housing program, which at the time was sort of called a voluntary 830G and was well intentioned, but it was dependent on a set of financial incentives, which then in the recession of 2008 to 2011 were taken away by the legislature, which is why that program never really got off the ground. Then in 2017, you had the initial requirement that every town prepare an affordable housing plan. And then you have Public Act 21-29, which in addition to the many substantive changes to the Zoning Enabling Act, which I'll get to in a moment, mandated that every town have an affordable housing plan prepared and filed by June of 2022. Now, a very important aspect of my working group's task was, and you may have detected this already, what we called the timing problem. So the legislature in 2021 directed all the towns to prepare and file plans by June of 2022, but we were also directed, the working group was directed throughout 2022 to come up with guidance. So while the towns were writing their plans, our group was coming up with guidance, even though a lot of the plans had already been filed. So it was a little bit of working across purposes, but we decided to use the overlap to our advantage, and really, as the plans were filed, to review them and use them, if you will, as a real-time laboratory as to what the towns were doing well and where they could use additional guidance. So our report, as adopted last month, was shaped by this legislative history and context, our specific assigned task, and our review of the plans as they were filed. Another side note is, if you look at our report in Appendix A, you will see links to the OPM and Southeast Connecticut Planning Group websites, where you will find links to any of the individual plans if you're looking for those. So just so you know where those resources are. And we also acknowledge that there was in 2020 a very good planning document, a guidance document prepared by the Department of Housing and the Regional Plan Association. But the report that we've just finished a month ago is different in the sense that we had the benefit of the more than 100 of the filed plans. And also we are the first one to explain the 2021 changes that the legislature made in the Zoning Enabling Act. So with that background, let me launch into the report. And I'll start with what the working group came up with in terms of 7 points of consensus. Number one, towns have a very significant role in whether, where, and how housing gets built. Number two, Connecticut is a highly segregated state, both racially and economically. Number three, municipal land use regulation and housing policy has the power to mitigate segregation in all of its forms. Number four, Connecticut needs tens of thousands of additional lower cost housing units. Number five, new and rehabilitated housing has to be balanced with the built environment and environmental protection. Number six, we are a state of urban, suburban, and rural communities. And seven, for all of these reasons, we very consciously tried to stay away from any one-size-fits-all program and decided early on that our report had to be a menu of choices from which towns could pick what would be appropriate for them. In our work, we recognize that single-family homes are the predominant land use in Connecticut by far. that higher density development has impacts, both positive and negative, that clean water, clean air, and open space need to be protected and preserved, that infrastructure, sewer, water, roads, utilities cost money, sometimes a lot of money, and the climate change, sustainability, green building, renewable energy, and disaster resiliency all need to be accommodated whenever one is dealing with planning for affordable housing. And finally, we recognized the challenges the towns faced in preparing their 830J plans. Unfunded mandate. Some towns have, many towns maybe have limited staff and funds. We recognize that there was both overt and latent opposition to the very task of preparing affordable housing plans. And another reality was that towns did not have a lot of time to really digest and understand the 2021 changes before they were asked to file their reports. So let me turn to our review and conclusions about the reports themselves. By the time we cut off the time frame, we had reviewed 120 of the reports. I think between 150 and 160 were eventually filed, but there were some, including some of the larger cities, that just did not get to the task. But that's another issue. So again, I'm summarizing the conclusions that are stated in our report. Most of the plans did a very good job in coming up with a local housing needs assessment, identifying, for example, what percentage of households in the municipality are cost burdened by rent or mortgage costs. There were several towns that did a good job with identifying specific areas where lower cost housing could be built and recommending regulation changes that would facilitate that. Several of the cities with the highest percentage of affordable units had very thoughtful plans about how to manage their diversity. I would call out Meriden and New London as being in that category. Appendix E to our report, I want to give a shout out to the town of Suffield, which, and I don't know where they got this, but it's a one-page photo mosaic, and I do hope you take a look at it, that really nicely illustrates all the different types of housing and households that populate our housing units, both affordable and market rate. Very, very eye-opening one-page set of photos. Again, take a look. So that's the good news. What emerged as a list of things needing improvement were excuse me, quite a few towns spent pages explaining why they do not need and do not plan to accommodate planning for affordable housing. Several set what I would call minuscule goals, 5 to 10 units over the next 5-10 years. And these are in towns with thousands of housing units. Several suburban and rural towns suggested that our cities have lots of affordable housing, so please don't pick on us. And almost none of the plans, and again, this may have been a timing issue, but even those written in 2022 recognized the Zoning Enabling Act as amended by the legislature in 2021 as their current obligation to amend their existing regulations to comply with state law. That said, by far the biggest concern identified by the working group and a characteristic of at least a majority, if not a clear majority of the plans, was the absence of specific actions, locations, and timeframes for producing more housing. Not identifying where affordable housing can be built and what regulations needed to change to make that happen. I will tell you that the majority of the reports gave the impression that after assessing housing need, the drafters looked at their regulations and zone changes and specific locations and sort of backed off and said, that's the untouchable third rail. We're not going to go there, which I understand is a reaction to local opposition, but that is a characteristic of the reports that jumped out. So with all due respect to, and I'm sure many of you on this call labored over those reports, the impression is that the mandate of the legislature created an opportunity for towns, many of who have argued for local control, to show what they could do. But the result was that relatively few towns ended up preparing plans with specific action steps. So if that's disappointing, I'm sorry. Again, don't shoot me. I'm just the messenger here. But reading 120 plus reports, that was the conclusion that we came to. We also spent some time looking at the procedures for establishing a local process for creating an affordable housing plan. As we said in the report, we don't really have any epiphanies here, but we did compile a list of best practices, a solid needs assessment, a plan for public education, focusing on specific actions that will lead to creating actual units, identifying barriers, identifying specific locations, enabling higher density, and assigning clear responsibility and timetables for taking those steps. Okay, now I'm going to go to a couple of slides to as visual aids to talking about section 6 of our report, which is the requirements that are now in the law with regard to Public Act 2129. And we call this in the report the low-hanging fruit. These are objective requirements that are now part of the law that every town should be complying with in short order. So you have, they include town regulations cannot ban expressly or in effect multifamily housing, more than 4 units. There are more than 20 towns around the state that do so at the present time. You must eliminate minimum floor area regulations that exceed the building and the housing code. So just to give you the order of magnitude here, the minimum in the building code is 320 square feet for a housing unit. And there are still some towns around the state that require for homes or residential units more than 1,000 square feet of floor area. One that probably many of you are familiar with is eliminating excessive parking requirements, noting that there is an opt-out procedure that some towns have used, but a town should have a solid reason for opting out. And again, a side note, if you think about it, just these 2 points, eliminating excessive floor area regulations and excessive parking, those 2 things by themselves have the potential to open up the density on a given parcel of land fairly significantly. The towns also need to adopt, this is one you're probably also familiar with, the statewide standards for alternative dwelling units with the opt-out procedure that, my impression is that more towns have opted out of the ADU standards than have opted out of the parking standards, but that I haven't done a count, and actually I'm not sure anybody has done that, but that's an impression. You have to eliminate numerical or percentage caps on multifamily units. And very importantly, you need to eliminate regulations that talk about preserving the character of the town as a zoning criterion. You can now do that only based on structural or architectural characteristics, not the subjective feel of the town. Next point is very important because it's widely misunderstood, and this involves the 10% list that is part of the 830G statute and maintained by the Department of Housing. Everyone should understand that achieving 10% of a town's housing stock on the Department of Housing's 10% list provides the town an exemption from 830G, but does not mean that the town has met a state of Connecticut goal, standard, quota, or policy for affordable housing. And as an aside, I have the imprimatur of the Department of Housing to deliver this message today. So this is widely misunderstood. The annual 10% list is an annual count of government-assisted and deed-restricted units, but it is not an evaluation of whether the town has satisfied housing need, and it is not a metric to determine need. One way to understand this is to consider that affordable housing, generally speaking, is within the economic reach of those earning 80% or less of the median income, whether that's area, median, or statewide. That, roughly speaking, that is 40% of the population, 80% of the 50% point. So achieving 10% on the DOH list does not mean the town, a town has met the local or regional need, and the state has not set that as a goal. So if you have an 830J plan that sets as a goal reaching the state's 10% quota, or words to that effect, that should be revised because it is a misunderstanding of the 10% list and state policy and law. Okay, moving on. The second part of complying with state law and 2129 is more subtle and more difficult. Each town, the report basically exhorts each town to review and identify those regulations that have the effect of excluding multifamily housing, such as through onerous conditions of approval or procedural requirements, large minimum lot sizes that may be hard or impossible to meet, for example. We want you to look for regulations that prevent or inhibit diversity and choice in housing. Example, requiring a special permit for a small multifamily housing development where it's not required for single family, or requiring public sewer for density, even though it may not be needed from a public health code standpoint. You want to look for regulations that, again, in effect, maintain or promote racial or economic segregation. You want to look for regulations that, quote, do not affirmatively further the purposes of the Federal Fair Housing Act, which at a minimum is making sure that information about affordable housing is widely disseminated on a town-wide and regional basis. And you also want to look for any regulation that has an adverse impact on housing costs, but does not serve a legitimate purpose of zoning. It exists primarily or exclusively to make housing more expensive. Again, perhaps not in an intentional way, but in a backhand way. So another way to say that is, another way to understand what you're looking for is to ask of each regulation, does this increase the cost of housing? And if so, what is its regulatory purpose? So now we move on to the menu that I talked about earlier, the list of criteria and characteristics that we encourage you to review. The first is increased density, and don't be afraid of density. Remember that the key to density is design. I always say I can show you, two units per an acre that looks overly dense and 25 per acre that looks just fine. Depends on the context and the design. Review your definition of buildable land. And by the way, there's a long list here, so I'm going to go through these somewhat quickly, but we can hopefully, if any pique your interest, we can get to it in the Q&A. Review the town-wide balance of single family versus middle housing versus multifamily. Every zoning regulation set of regulations should allow some of each type of housing if you're going to have economic diversity. Consider where housing can be rehabilitated if it's not going to be newly built. Don't limit your potential builders to just nonprofit and government. Make sure that there is a place there for for-profit builders. Moving on to the next slide, you should make sure you specifically plan for the most needed unit types, which are units for people with disabilities, units for households earning below 30 to 40% of median income, and units with 3 or 4 bedrooms. You want to review your design standards for necessity and unnecessarily added cost. You want to review your regulations for what we call actual buildability and practicality. For example, if your regulations have a very short permit expiration, that might be a deterrent. That could result in a regulation that appears to allow the housing, but is going to be impractical and is going to drive applicants and builders away because they're afraid that they get their approval and then they can't convert it into construction quickly enough. Identify and eliminate unnecessary procedural requirements. For example, do you really need notice by certified mail to everyone within 500 feet of a site plan modification? Some towns have that. Review your non-residential zones. Which ones could accommodate housing or a mixed use with housing? Specifically plan for middle housing, 2, 3, 4 unit structures, bearing in mind that they can often be developed without public sewer. Next topic is one that's received a lot of ink and discussion in the last 2 years, transit-oriented development, hot topic at the moment. As you may know, the governor is pursuing a bill with some fairly significant financial incentives. And if your town is able to look into that and take advantage of that, you should do so. You want to consider financial steps, making sure your residents are aware of lower cost mortgage sources such as CHFA and the U.S. Department of Agriculture. Consider targeted property tax relief, sometimes done for seniors, sometimes for lower income, but it's a tool that is readily available. Making sure that the availability of rental assistance certificates or vouchers is known throughout the municipality. Consider an affordable housing trust fund. Consider making payments that buy down the cost of existing units, and consider making information about rental opportunities accessible to all of your residents. Next, you want to consider what steps have immediate versus longer term impacts. The financial steps that I just talked about would probably be a good example of something that can be implemented in the short term. Regulation changes probably have a longer horizon to become effective. There's always talk around the state about inclusionary zoning. I think the message of the report is to proceed with caution. It works in some places, not everywhere, but it is almost universally difficult to set up and difficult to administer. Consider relief from from strict non-conforming use rules. Understand that zoning is not a promise. Existing property owners have to understand they're not entitled to freeze existing zoning on the basis that I paid for my house or my property based on one set of regulations, and they should never be changed. That's not the law, and it's not good planning practice. Recognize that residency preferences are generally illegal because they maintain segregation. Be sure to review, in addition to your zoning regulations, subdivision, wetlands, sewer. Make sure that your local POCD is consistent with your 830J plan. As a side note, the good news on the 830J front is that the Connecticut Housing Finance Authority, when it grants federal low-income housing tax credits, is now granting extra points if the proposed development is consistent with your 830J plan. So specificity in the 830J plan actually will help in the delivery and allocation of low-income housing tax credits. And it's could be a very important point in financing affordable housing. Make sure you conduct value engineering. That's another term for making sure that there's no unnecessary costs that result from regulation but don't have a valid regulatory purpose. And then lastly, please consider what we call the grid exercise. If you look at the appendix to the report, there are a couple of examples, a couple of towns, and I don't remember which ones they were, but they made a chart of all of their zones and which ones allow housing and which form. And when you do it in a grid like that, the opportunities and the gaps jump out at you. It's, oh, we can increase the density in this zone and that zone. And why is housing not allowed in this zone? So it's a very useful little tool to try to figure out where the opportunities are. And finally, our report made legislative recommendations. There was a lack of clarity about who actually adopts an affordable housing plan. The legislature, we thought, should require periodically, maybe not every year or 2 years, but periodically, updated housing plans against the content and recommendations in our working group report. And a suggestion to which I will credit Glenn Chalder is that Department of Housing propose and publish additional models for affordability plans dealing with some of the difficult administrative issues like how to treat capital improvements and utility costs and so forth. So I'm going to stop talking. I'm going to leave you with these takeaways on what is next for affordable housing in Connecticut. Number one, conform your regulations to Public Act 2129. Number two, examine your regulations for unnecessary and illegal barriers. And number three, recognize the plans that have specific relocations, specific regulation changes, and specific zone changes and policies will be the ones that will succeed in moving affordable housing forward. So thank you for your time, and I turn it over to my colleague, Andrea Gomes.
Thank you, Tim. And thank you to the CCAPA for having us. As Tim mentioned, and as Emmeline mentioned at the beginning, I am a land use attorney by day, fortunate enough to work with Tim at Hinckley Allen, but I am also a volunteer commissioner on the West Hartford Town Plan and Zoning Commission, and it's combined with the Inland Wetland and Watercourse Agency. To be clear, I am not here today on behalf of the commission, the agency, or the town. I'm simply allowing my experience on both sides of the aisle, if you will, to inform our discussion today. So I'll dive right in, and I'll start perhaps by stating the obvious, what you gleaned through Tim's presentation, which is that the housing crisis has been with us for quite some time, and it's not going away anytime soon. The National Low Income Housing Coalition provides that Connecticut is the 10th most expensive state for housing in the country. And to put an actual figure on this, a Connecticut worker earning minimum wage needs to work 2 full-time jobs to earn a basic 2-bedroom apartment in Connecticut. That gives you a little bit of an idea of what we're facing in this crisis today. So what can municipalities do to address this shortage, and what can they do to encourage development of this much needed housing? And what we'd propose is 4 basic steps, some of which Tim went through, but we'll dive in a little bit deeper here. The first step I think is extremely important, which is outreach and education. First, you need to educate your local commissions and boards on the current law, and you need to be clear on what they can and cannot do pursuant to state law. Commissions, which are often comprised of well-meaning laypersons, so to speak, non-lawyers, if you will, don't know the law, but they're still asked to apply it on a very frequent basis. Without guidance, it's easy for a lay commissioner to misunderstand what the law requires. For example, we've seen a number of commissions demand parking in excess of the parking standards set in General Statutes 8.2, which was amended by Public Act 2129, even when they haven't gone through the opt-out process. This is a violation of state law, plain and simple, and some education may curtail that type of thing happening. It's important to educate your commissioners in particular before an application comes in. Consult the town attorney, of course, if that's something you prefer. In one fairly recent 830G application that Tim and I worked on together, staff actually coordinated a presentation on 830G by the town attorney for the commission before our public hearing opened. So they actually pushed our public hearing out to the following meeting to allow the town attorney to come and at least lay the foundation for the commission on an 830G application. It ensured, again, laid the foundation for the commission and ensured that we as the applicant were not starting the public hearing without any guidance whatsoever. We, of course, as applicant attorneys, discuss the applicable standards and the law in our materials and in our presentation, but setting the stage beforehand saves a lot of time and is really invaluable. It's also important to educate the public on what affordable housing is and what it isn't, to work to dispel myths. Unfortunately, in our day job, so to speak, we still see a lot of NIMBYism, much of which is unfortunately based on inaccurate and improper stereotyping or misunderstandings regarding affordable housing. We, again, as applicant attorneys, work to dispel those myths during the public hearing process, but with community outreach in advance, a lot of this can be curtailed in a productive way. You can engage in a conversation with your residents and your neighbors before an application even comes up. Apologies. The second step would be a review of your regulations, regulatory review and amendment, so to speak. The legislative body in each town needs to undertake a wholesale review of its zoning regulations. Yes, part of that review necessarily requires amending the regulations to comply with the state law that Tim mentioned earlier, the low-hanging fruit, as he called them, which include, for example, eliminating floor area regulations that exceed the building and housing codes. But the review should also include amending those regulations which have the appearance of being neutral, but which in practice severely limit or impact the ability to develop diverse housing. A great example of this is minimum lot size. Some towns provide for single family housing and then provide for multifamily housing of a greater number of units, for example, 4 or more units, but completely ignore middle housing, your duplexes and triplexes, sometimes your quadplexes. Simply by ignoring them in the regulations, but including provisions like a minimum lot requirement, can certainly curtail the development of the housing for the missing middle. And a way to approach this, I'll reiterate it again as to what Tim said during his presentation, is ask whether a particular provision or a section in your regulations increases the cost of housing. And that certainly includes the increase of developing that housing. And if so, what is the regulatory purpose? If it increases the cost and there's no regulatory purpose, that's a red flag that it should be evaluated and perhaps amended. The third step is zoning map review and amendment. Municipalities, the same way that kind of that grid that Tim mentioned, it's really helpful to put a visual of what uses are permitted in what zones. Looking at your zoning map is equally helpful. While the regulations in your particular municipality may provide for multifamily housing in certain zones on paper, you don't really see the impact or the practice of those regulations until you see them on a map. Where are the zones? How big are they? What zones are they close to? All of this matters and can impact the viability of an affordable housing proposal in your municipality. For example, if you permit multifamily housing, but only in a single zone located in a negligible area of town, you're really limiting the availability of housing in town. Similarly, if you permit multifamily housing in a zone located in an area with no infrastructure, but then also require that multifamily housing be connected, for example, to sewer, you are again limiting affordable housing, even if it doesn't appear to do so on paper. Second, a wholesale zoning map review will allow each municipality to proactively identify where it believes affordable housing should be developed. And it may even, you can do that on the general level, you may even be able to identify some specific sites. We handled one application, Tim and I handled one application a number of years ago where the town actually approached our client with a proposal to build an 830G multifamily community. The town recognized that it needed additional housing, knew that this particular parcel would be available, and approached a well-known developer in the area to get that done. Don't get me wrong. The local commission and staff certainly put us through our paces and ensured that the application was properly vetted, as they should. But partnering with the town for a site that the town itself believed was ideal for this type of housing was a great way to start the development process, and the lines of communication were open throughout the entire process. We see many municipalities that say that they want affordable housing, but not here, but they don't take the extra step in identifying where here is. Reviewing your zoning map in conjunction with your regulations can help ameliorate that issue. Fourth and finally is reviewing the application process or procedure that you have in place. Those procedures that at best have no valid basis in zoning and at worst operate to limit housing, diverse housing opportunities should be revisited and amended. A perfect example, Tim alluded to this in his presentation, is reviewing fees associated with land use applications. We have seen some absolutely exorbitant fees in the thousands and tens of thousands for relatively straightforward multifamily applications. General Statutes 8.1c requires that application fees be reasonable. That's generally interpreted to mean covering the administrative costs of staff and the town processing the application. Anything above that is really considered an illegal tax and operates to prevent the development of diverse housing opportunities in your town. Another good example that we see quite frequently is to examine your local procedures for minor site plan amendments. Those procedures often contained in the zoning regulations. You'd see this while engaging in your wholesale zoning review, but we've seen some towns require zoning approval for revisions incorporated into a site plan in order to comply with building code during the building permit stage. The revisions had nothing to do with the use or the operation of the use. but nevertheless needed zoning sign off, which of course added on additional time and additional cost to the land use approval process. We've also seen a number of municipalities that don't even have a minor site plan amendment process, or worse, have it, but never use it and just immediately send things to public hearing, forcing the applicant to go back to the commission, oftentimes go back to a public hearing for even some of the smallest revisions to a plan that, again, really don't impact the use or the operation of that use. The procedures that I just mentioned and a host of others that we see on a daily basis take a lot of time and they cost a lot of money. And again, they don't have any valid basis in zoning and will dissuade developers from coming forward with diverse housing opportunities for your municipality. So how do you start? How do you engage in this 4-step process? What we'd suggest is creating a specific plan with actionable goals, realistic timeframes, and assigning specific people or departments to meet those goals within those timeframes. One great example that I see in my position as a commissioner in West Hartford is we have in West Hartford what we've called for our POCD, we call it the POCD implementation matrix. A version of this is actually located at the end of the West Hartford POCD. And it's a document that looks almost exactly like an Excel spreadsheet. It lists the numerous action goals that we have in our POCD, responsible parties and timeframes. As a commissioner, what staff does is they'll provide us with the updated implementation matrix on a periodic basis. And in so doing, they're constantly updating this document. They check in with the TPZ on what our priorities are, and adopting this framework in the affordable housing context will help each municipality get things done in a reasonable amount of time. So with that, I will hand it over to Chuck.
Thanks, Andrea. I'm following up a little bit on what Andrea did, is that I'm also serve on a commission and a lawyer, and I'm going from that. I've got two sort of topics I'm talking about. Number one is sort of the tips based on serving as a land use attorney to municipalities and also sitting as a member of Planning and Zoning Commission. And the second thing is ways to ensure that affordable housing deed restrictions are actually enforceable. So those are the two general items that I'm intending to cover. First of all, I'm never sure why I get asked for these things. Unlike Tim and Andrea, I don't represent developers in 830G, and I haven't served on the commission, on the legislative commissions. And then, and I ask, Evan Inman, well, you serve both as a municipal attorney, correct? Since the late 80s, I've been an attorney and represent many municipalities. And you also serve as a commission, and that's also correct. Since the 90s, I've served on the Branford Planning and Zoning Commission, and since 2015, I've been the chair. So I thought what I try to do is to give you a sense of the dynamic from being that dual rule, and maybe come up with a couple of tips for that. From again, and the difference here is that I serve on the municipal side, and Tim and Andrea are mainly representing developers. Attorney goals representing a commission there's really two. It's that please follow the law, and please, if you're sued, I want to win. So follow the law, win your appeal. That's the advice I give when I'm advising it. I'm representing a commission. I want to do those two things. Pretty simple, right? And it's not that different than what most lawyers would do. If you're going to go in and file your taxes or get your estate planning or whatever, those attorneys say the same thing. We want to, follow the law, and if you get sued, win. So it's not a lot of difference for zoning, but I've said that, a number of times, and I kind of mean it. This is what the law is. I want to do it. What's your goal as a commission member? When I'm sitting on a planning and zoning commission, frankly, when you get into that mindset, and when I'm in it half the time, following law is the main thing on my mind. The main thing, probably, I think goals as a commission member is you want to do what's best for the town. And frankly, I distinctly remember when the former chair had been there for 30 years, retired, had a little reception. He says, do what's best for Brantford. Okay. So, and I think most commission members act in good faith. That's where, that's their main goal. And so the issue becomes, do these goals, the goals as the attorney and the goals as commission member, do they conflict, particularly in the affordable housing context, and specifically, I guess, more specifically in 830G context, because there may be no conflict. I mean, we've approved things for, for different zones, affordable housing, voluntary stuff, whatever. But what about in the affordable context do these things, conflict? And probably most of the time the answer is no. I think there's a lot of affordable housings that have been proposed and approved, and they're good even in suburbs. I frankly don't know any town that opposes ADUs, even if they have opted out. There's probably some out there, and someone will tell me that, but I think they're adopted in most towns, and that's been an evolution. I know in Brantford we've had them since the 90s. The opposite, and even the middle block housing that Tim described in the report, that even in a single family in duplex areas, putting in that middling type housing and blending it in, I've seen those approved, some ragging, whatever, those approved without issue. The main sort of project that I've seen as being the problem, is where you get the upset, is where you have this big block stuff, the big 3-story, 4-story, 60, 80 units in the middle of a single family zone under 830G. And no surprises, those have, that's been a problem by some commissioners. And I'd say the mentality of the commissioner is, it's almost the civil disobedience mentality. Remember Martin Luther King from the letter from Birmingham jail? Why are you disobeying the law? Said the white preachers. And he said, because I'm following a higher law. And if you ask the commission members, they'll say, this is the law, but I'm following a higher law. This just isn't good for the town. So anyway, that you won't go into that, but that is kind of the mentality. So what do you do in that mentality? And again, this is minor, whatever. I mean, because a lot of stuff's good, but whatever. So what's the revelation? What's the tip coming out of that dynamic, which I've observed? My practice tip number one is that, again, from the commission member, with any 830G application that comes in front of us, and Andrea kind of mentioned it as a great example. They had in West Hartford that they had the attorney explain 830G to the commission. But when I open a public hearing, it's an 830G application, I'll say right at the beginning of the thing, we're opening this hearing. By the way, this is an 830G application. Here's what that means. That means that in the event that we deny the application or approve it with conditions that the developer disagrees with and constrains the project, they can file an appeal. And it's the commission's burden to show that the reasons for denial are based on substantial public interest in health and safety or other matters that the commission can reasonably consider. So the substantial public health and safety issues, and that those public interests clearly outweigh the need for affordable housing, and they can't be addressed by reasonable conditions. So in other words, you say it right out front, right at the beginning, this is different. It's kind of like telling the developer up front, yeah, we recognize that, we do it. It's telling the public, well, this is a new story, maybe can guide your comments to the public health and safety stuff. It tells your commission that, okay, guys, this is it, this is what we're on. And it tells the court, because these things often end up in court, that we're right in the beginning, that we know this stuff right from the beginning. So anyway, that was sort of practice number one. Practice number two is, if there's any way to make it easier for commissioners, please do so. And what I mean by that, and I'll give the example that Tim was involved in. We had the case in Brantford where the developer, was that kind of a case where the developer appealed a condition of approval, found it to be improper, won the appeal, and we got a remand that said, you have to approve this application, striking the condition. The attorneys worked out the conditions and brought it before us to approve. And then, because here's what happens in these things, the dynamic was the thing had always been approved by a 3-2 vote anyway, and then they just appealed the condition. And then sure enough, one of the three members was gone and an alternate steps in. So we had this 2-3 vote of approve the remand. And I'm thinking, what, we're ordered here. What do you do? What do you do? And I did something as chair that I rarely do, because I was one of the two that voted for it. I'm a lawyer, but I begged the one of the people who voted against it, because they can only make the motion to reconsider, to make the motion to reconsider and to do so. And I said, look, you're on record opposing this. No one's going to say you sold out. I read the remand of the order that said, you must approve this. And I said, you know what, as a lawyer, they got to lay up for contempt if we deny this. And sure enough, what one of the commission members said, well, can we do it under protest? I said, yes. You can make that under protest and frankly, whatever, that makes their record clear and whatever, it got approved under protest and, you know, save faith for somebody, whatever. I don't know, that's not universal, but whatever, it's an example of something. So anyway, that's the tips. Now I'm going to go on, what time is it? Because I want to talk about my second topic, which is the enforceability of affordable housing deed restrictions. And here's the issue. The issue is, how do we ensure that the units are occupied by the target population? The deed restrictions are all over the place now. How do you ensure that they're being enforced? And this is something that actually Glenn Chalder had recommended that I cover in my enforcement outline when we did that for the CCAPA seminar. So I have a section in that if you're looking for something written. The issue is this, that the developer manager typically just wants the rents. They don't have a lot of incentive to make sure that the actual target population is within the units. And the zoning staff isn't in the business of doing this stuff, right? You're not going to go in and ask for your, you know, give me an authorization so I can call your employer to check out your income, or, you know, give me your income tax return. And so how do we do this? It turns out we have an employee in our office, in our law office, who actually is occupied it resides in a restricted unit in a workforce housing development. And I said, okay, how do they do it with you? So, you know, in real purpose. And what they do is they send out a form saying, what's your income, what's your assets, and sign and say that's true. So you know, under affidavit, and that's what they do. And the issue with that is easy to cheat, right? They make no effort to verify that information, to determine that the income information is accurate or anything else, but they, you know, simply have you certify that. So, you know, and she showed me the form, and I assume that's typical for a developer oriented, it's assumed that's, you know, providing the assurances for the 830G. What the current law says in this 830H, it requires the developer to file an annual certification of continuing compliance for any approved 830G plan. And the problems, first of all, that only applies to 830G. What about other affordable housing units? But are they doing the due diligence to ensure that the certification is accurate? And I would say that's, you know, what I saw, the example I saw probably is not. So here's the recommendation. The main, and this is based on speaking with Glenn and a few others, to, first of all, you cover this in your affordability plan for any deed restricted unit. And Glenn recommends adopting a universal one, you know, that apply to any deed restricted, whether it's 830G or not 830G. You do have to have an affordable housing plan, maybe not for other ones. And that the town approves the initial administrator and takes any changes in the administrator, reserving the right to require the owner to hire a third-party administrator. And that administrator qualifies the renter owner as eligibility in the annual compliance. So the key is getting, I think, an independent administrator to do, and someone who knows how to do it, to actually fulfill that role. Two examples. One is in Guilford. We approved a affordable housing application in Guilford, and the administrator there, the developer agreed to hire the Guilford Housing Authority to serve as the administrator. They're in the business. They do it anyway for their own affordable units. So that was a good choice, and they paid them. So that was I think a qualified person to do it. Another town has a list of recommended third-party administrators that you can hire, that you can do this. I think the example that I talked to was Bethel, that particular administrator charges, I think, $250 to do the review for rentals, $500 for a sale, and does the yearly affidavit, and also will do spot audits to make sure it's actually good. So that's some suggestions for that. Resources. Michael Santoro of Department of Housing, he's the guy that reviews, you know, the affordable housing plan. He's a contact. If you have questions about that, he's good. Examples of affordability plans that he recommended is good. One was Guilford for the Hubbard House, and another is Ridgefield. You can look online for that. So that's what I got.
Okay. Since while Andrea and Chuck were talking, I'm the one that has had the opportunity to go through the Q&A. And if I see we're just 1 minute past 5, but I'm going to try to take 2 minutes and run through the questions because I think I can answer them in fairly short order. One question was, does Public Act 21-29 require multifamily in all zones? No, it requires that, or it states that a town cannot ban multifamily altogether from the town. It does not go beyond that. Second question was making the point that sometimes it takes a lot of expertise and information to identify specific sites, such as evaluating wetlands. Yes, some sites are harder than others. An infill site in the middle of the town center might be very easy. Raw land in a rural area might be much more complicated. So that's just one of the realities. It's that evaluating some sites is difficult. Sometimes it's not so difficult. Is the report available? The report is on the invitation to this webinar, and you can also, if you send me your email, I will send you a copy also. We will make the slides available from what we use today. I can't read my own writing. Oh, is the recording going to be available? Yes, I believe it will be through CCAPA. Now, there are a couple of questions. How can we expect towns to get to the 10% if the cities, major cities, are the ones that have most of the rental certificates and other things that are counted? Let me please go back to what I tried to say before. 10% is not a goal. It's not a standard. The idea of 830G is not to require or even encourage. There are some towns that will never get to 10% because just of where they are statistically. But the point is, we want you to create affordable housing. There is the moratorium procedure as a 4-year moratorium, as a carrot, if you will, for those towns that actually produce affordable units. But the goal here is the goal of 830G is not, and the expectation is not necessarily that a large number of towns are going to get to 10% and then you wash your hands of affordable housing. That's not the goal. That's not the point. Another question was, can't we just redefine affordable to include what is sometimes referred to, and this is my term, naturally occurring affordable housing that's not counted on the 10% list, but actually is affordable. The problem with that is, how do we do that on an annual basis? One thing about the 10% list is based on categories that are easily countable: rental assist certificates, government assisted units, where there's a program that says we are funding X number of units in X number of municipalities, deed restricted units. If we're trying to capture on an annual basis naturally occurring affordable housing, we have an impossible administrative task for the town staff and the Department of Housing, which is why that's not done. So that the legislature's answer is not to redefine affordable housing, it's to create this exemption process for 830G, but not to go beyond that, otherwise to be prescriptive under 8-2. Here's an interesting question. Does Public Act 21-29 prohibit a moratorium on multifamily housing? Tentatively, my answer is no, but bear in mind that any moratorium is a very high bar. You would be creating a moratorium on something the legislature has said you have to encourage, but there is a body of law that says if you have a very valid reason for a pause on a particular type of development, you can implement that if you go through the proper procedures. So with that, I think I caught all the ones that were in the Q&A. And Andrea and Chuck, anything you want to add to what I said on any of those answers?
I'll just add that there's a proposal, and I don't believe it's going anywhere, but there is a proposed bill to redefine affordability for purposes of 830G currently percolating at the legislature this session. And I think it is meant to capture some of that naturally occurring affordable housing. I think the proposal to redefine affordability happens quite frequently, if not on a yearly basis, but for the reasons Tim discussed, they just don't get any traction. Administratively, they're very difficult to capture.
I mean, I agree that the 10% list isn't, when you say affordable, you think of inexpensive, and that's not what the 10% list is. Mainly government subsidized and deed restricted, which doesn't capture the universe. So I understand that. I understand the logistical problems that Tim mentioned as well. I mean, in many ways, what was interesting to report to me is the recommendation is watch out for inclusionary housing, which is because on the one hand that's what the state's encouraging in order to get, on the other hand, they're saying, watch out for it. I mean, part of me has always been saying increase supply, and that, you know, and that seems to be a goal of a lot of developers too, you know, and let the market work it out. I mean, that's the ideal situation, but
Yeah.
I don't
No,
know.
inclusionary zoning is a very highly debatable. It's in some places it works great. It is very hard to set up, and even your own remarks, very hard to administer sometimes. So, okay. All right, we're 7 minutes past the hour, and we have 100 and plus people who very kindly stuck with us until going past the hour. So I think at this point, Emmeline, is there anything you want to cap off before we sign off? Yeah, you're muted, Emmeline.
Sorry, I just want to say thank you so much to our panelists. You know, I find that whenever our local land use attorneys speak, I always learn something. And so I certainly appreciate you presenting this topic both to my planning colleagues throughout the state as well as planning commissioners. And this will be available. I'm going to check with Evan. I believe that we can do a follow-up email to those registered participants and make sure that you get the link to where this will be posted on the CCAPA website as well as the presentation. Thank you.
Okay. Thank you, everybody. Thank you
Thank
for
you all.
listening. Bye.